Hi, everyone. Harry here to talk about DA Alvin Bragg's response to Donald Trump's motion in the trial court to set aside his conviction on 34 counts based on the Supreme Court immunity decision. Okay, so it's a methodical, comprehensive, well-done motion. I will march through at least some of the main arguments, but just for those who might just want the sort of top line context, let me start by saying this is in the trial court. So when you're appealing, you bring it first, typically, unless you get permission not to, in the trial court. And the trial court under New York law and generally is empowered to set aside a verdict for any reason that an appellate court could set one aside, some others as well. But basically, this is the exact kinds of arguments, the exact arguments that we will see in the appellate division, the New York second level appeals court, and the same sites, the same everything. But we're in the trial court, and I expect we'll see. But this is Justice Juan Merchan who presided over the trial. And this is actually one ruling that I think could well come before the election. It's simply the trial court saying no and protecting the convictions that the jury in his courtroom found. But it's a little bit of news, and it will be a little bit of news. So that's one sort of procedural point. If, assuming Trump loses, then we take this exact package. We know now what it's going to look like up to the appellate division. Second, this is under the immunity decision. And we sketched this out at the time when Trump filed his motion, but he's saying two or three things. He's saying, first, this is immune conduct. Recall that's the basic distinction between official acts and unofficial acts. And he's saying that he was prosecuted for official acts. Pretty hard argument to try to make. But then he's saying, and this is really where the action will be, that he was prejudiced under the Supreme Court immunity decision because Merchan introduced or permitted the DA to introduce certain evidence, and as part of the Supreme Court's wildly overreaching immunity decision, they've said even that you can't, even if you're proving unofficial acts, you can't introduce official conduct. So remember that. We have Hope Hicks in 2018, when he's president, talking about a Wall Street Journal article that has uncovered the fact of the payoff to Stormy Daniels of the hush money and the like. So what we have in very broad strokes from Bragg is, first, as to much of the evidence he's complaining about, he waived it and didn't bring it up. Second, it fails anyway. For example, it's not official conduct, it's unofficial conduct. And then third, and a big fallback, any error in introducing evidence was harmless. That is to say, and this is a universal doctrine in criminal courts, if you look at all the evidence and the evidence was overwhelming and a reasonable juror would have found, you got to do the sort of counterfactual in your head, but a reasonable juror would have found guilt, even without the evidence that's now complained about, the verdict stands. You don't want to, start all over from scratch at step one because of an inadvertent error. This would be, nobody could have seen the exact terms, especially this very broad aspect of evidence in the Supreme Court's immunity ruling. So this would have been something that was sort of stumbled into by the trial court. Importantly, though, for the waiver argument, I was struck and hadn't seen that in terms of bringing it up, you're charged with raising the claim, even though it's now based on an intervening Supreme Court decision. You can still waive by not having brought it up before the decision came down. So there's a lot of the evidence here that Trump is complaining about that he clearly didn't make any objection about. There's actually a few that they did, and most importantly, the Hope Hicks testimony. They did raise an immunity objection. It's a little murky whether they perfected it or followed through. But basically, New You've waived if you don't raise it. Okay, so very broad strokes, and now before diving in. So just to repeat, this is in the trial court, so you could see it before actually come out before the election. It's based on immunity, but writ large, which is how the Supreme Court writ it, with this, extra doctrine of you can't even use evidence because, take a step back, the context of this case is how more unofficial can you get than a candidate paying hush money to keep information from the American people before the election. And then more or less three-part argument as to different evidence. Trump is saying these 15 pieces of evidence should have been admitted. So the DA's response to all of them it's not identical. It depends on the facts of trial, but roughly we want to be thinking about waiver. He didn't bring it up, and so he can't now. Wrong on the merits. This is not. This doesn't fit in the Supreme Court. It's neither official conduct nor even testimony about official conduct. And harmless error. That's going to be a really big part of it. I think it's likely you're going to see a harmless error ruling by Justice Merchan, and that's typically because the trial court sits there, has seen all the evidence, saw it come in day by day, saw the jury. That's the sort of ruling that typically stands up on appeal. Of course, nothing about this case is typical, and you can certainly imagine an appellate division judge who is very skeptical for whatever reason, not just endorsing the harmless error analysis. Okay? That's broad strokes. Now let me just go through this, but in more specifics that will come up. So what's he challenging? What's he saying? He is trying, lamely to say this was official conduct in some way because it was consummated in the White House. Remember the scheme, he pays some checks there. But just because you're in the Oval Office doesn't mean everything you do is official. And the signing of those personal checks to finish a payoff to Stormy Daniels really won't cut it as official action. That's part of the argument, but the real hope that Trump has would be, by the way, for a new trial, not a reversal or anything, but a new trial, and it's based on pieces of evidence, essentially. Hope Hicks' testimony in 2018, Office of Government Ethics form, where he fills out financial obligations and the like, and then a bunch of tweets, some of which post-date the presidency. And that's the sort of first battle, big battle on the substance will be, are those official or unofficial? So let's talk about Hicks, because that really is the big part. She comes in the Oval Office. Oh shit, Wall Street Journal has the story, etc. They talk about it some. Trump actually says it's a good thing that this is coming out now, not before the election. That's really pretty inculpatory evidence. And then he says that that Michael Cohen had paid it all back himself out of the goodness of his heart, and Hope Hicks knows the President of the United States, is lying to her. And she as much as says that on the stand, and that's, I think, what makes her break into tears. Okay, so this is the Trump team best chance to say we introduced some evidence, the DA did, and it was of official action. But the DA, slices it pretty finely. First, what the DA basically says is, this isn't about, it's true, Hope Hicks is the communications director, but this isn't about communications. This is, they don't form any kind of outward facing, the way the DA phrases it, conduct to respond to. It's really just a sort of Hicks to Trump conversation that isn't official within the rubric of you're talking to your communications officer. And the court made clear that you can have conversations with official people and they're not automatically official. The example that they give here is not the greatest, though, because they give the Mike Pence case. And what the court said there is, sometimes Mike Pence, the vice president, is in his guise as president of the Senate. And that's not the same thing. So the court did come within an eyelash of saying, and maybe the appellate division will say the Supreme Court said that if you're in the Oval Office and you're talking to an official person, we're not going to slice it so finely as to say, well, it wasn't really outward facing. But that's the Bragg argument as to Hicks. And then there's the financial report. Supreme Court said you can have certain official records and that's not a problem. And I think that's going to come in without any question. And then all the tweets, Trump never objected to them at trial. I think the real action here is going to be with Hope Hicks. All right, what about, did he object to that at trial? Yeah, but let's move to waiver for a second. 2 points to note. The first is a little bit of field, but it matters here, and Bragg relies on it. Remember, Trump, tried to remove the whole criminal case to federal court. When you do that, it's a fairly similar inquiry to what the Supreme Court has now prescribed for immunity. Basically, were you taking official action? And he tried to remove it, he lost, and then he did not pursue the appeal. So there's an argument that he waived things about official conduct anyway. Then as to Hope Hicks, it's clear there's a couple times where he does object, and it's about official conduct, but he says it specifically about statements that Trump made. And again, this would be slicing the salami pretty thin, but you could say that he doesn't even object to anything other than that. And the testimony actually was admitted by the court. The DA proffered different reasons, and it was actually admitted for its probative value having to do with Michael Cohen and Michael Cohen's state of mind, and the idea from Trump about who paid back and who didn't. It's what was Cohen thinking when that money was transferred. That's the reason in theory. But still, we have the Hope Hicks stuff. So some argument about waiver, but not so solid. Then on the merits, some argument to say, look, this still is Trump in the Oval Office talking about paying off a porn star, and it doesn't matter that he's now has the seal of the presidency behind him. This is not official conduct. So that's the second thing. And then third, the big one, harmless error. And that is, a very sort of loose subjective. You look at all the evidence. Now, one problem with the Hope Hicks evidence is they really emphasized it in closing argument. The DA got up, told the jury this was devastating. But even if it was devastating, man, there was a lot of, here's where I feel I can offer something to you guys a little more, in terms of what Merchan will be thinking, because I was there at the trial. And, you take away Hope Hicks. The main use of her testimony was to say Team Trump was freaking out when the Stormy Daniels testimony hit in the immediate wake of Access Hollywood. And I'm sorry, that was proved overwhelmingly with David Pecker, with Michael Cohen. It certainly is available to Justice Merchan. I think it'd be the right ruling to say any error here had to be harmless, and that being the ultimate. So you could go on waiver, but especially with Hope Hicks, it's a little murky. You could say this just isn't official conduct, but you're at least, maybe Merchan would think, leading with your chin, because, this will very possibly go up to the Supreme Court through the Appellate Division, the Court of Appeals, the highest court in New York, and then the Supreme Court could take it. And so you could really be worried that would come back to bite. So I think it's going to be harmless error that'll be the focus here. That's the basic core that we've been focusing on Hope Hicks. If others kind of emerge, I'll come back to talk about it. But the short story here is Hope Hicks. That's his best shot, but I think at the end of the day, there's a pretty strong kind of safety net for Bragg, which is harmless error analysis. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.